Anyone else seek recognition? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Clinton.
Aye.
Mr. Blumenthal.
Aye.
Mr. Rono. Mr. Booker.
Nomination will be favorably reported to the floor. Next, we have Christopher Fonzone, nominated to be the Assistant Attorney General for the Justice Department Office of Legal Counsel. Does anyone seek recognition on this nomination?
Mr. Chairman.
Senator from Rhode Island.
Just to say that I've made considerable progress with the Department of Justice and will be voting yes in the committee on this individual with the expectation that that progress will continue.
If no one else seeks
Mr.
Senator
Chairman.
Welch.
Mr. Chairman.
Senator Welch first.
Requested documents that they just arrived, and we're in the process of reviewing them, so I intend to vote yes, but reserve my right on the floor. Thank you.
Thank you. Senator Cotton.
I'd like to say a few words about the nomination of Chris Fonzone to lead the Office of Legal Counsel. I don't believe that Mr. Fonzone should be confirmed to this very important and sensitive job. It's often described as the Department of Justice's law firm, and opinions issued by the Office of Legal Counsel are binding authority on the executive branch unless we pass a law or court rules to the contrary. It's not an insignificant job. It requires a very, very important sense of judgment and discernment. Unfortunately, I believe Mr. Fonzone has not shown that sense of judgment and discernment in the past. He worked in Barack Obama's National Security Council. He was well aware of the threat China posed to this nation, given his work on the NSC. But at the end of the Obama administration, he went into private practice, and in private practice, he willingly agreed to do work for Chinese communist-controlled entities like Huawei. In his nomination hearing for his current role as General Counsel of the DNI, I asked Mr. Fonzone about that representation and whether he could have turned it down within his firm. He said he didn't know. I suppose he never sought to find out. I guess he wasn't interested in knowing whether it was suitable in fancy law firms to decline work for Chinese communist-controlled entities. I suspect very much that it was just fine to turn down work for big tobacco companies or oil companies or other companies that are disfavored by the Democratic Party. But radio silence for Chinese communist-controlled or affiliated companies. Now, despite his work for Huawei, he's been in a very sensitive role at the Office of the Director of National Intelligence, and President Biden wants to put him in charge of legal rulings that could affect the entire executive branch. I think we should all ask ourselves a question, not just about Mr. Fonzone and about this roles. Should we confirm people who are well aware of the threat that communist China poses to this country, who have left government, left sensitive national security or foreign policy related positions in the government, and then gone into the private sector where they have worked with Chinese communist-owned, controlled, directed, affiliated entities? If they do, should they be invited back into the United States government, into positions requiring sensitive judgment and trust? I have nothing against Mr. Fonzone personally, and he's far from the only person who has worked in government left and done work in private practice for Chinese communist-owned, controlled, directed, affiliated entities. But I do think it's a practice that we ought to frown upon, to discourage, and to encourage people who are in law firms or investment banks or consulting firms or multinational corporations to think twice about willingly working for Chinese communist-controlled, owned, directed, affiliated entities. I think it would be a good thing if fewer people did that, and especially if they came back into the government. That's why I opposed his nomination to his current role, and that's why I will oppose his nomination to this role as well.
Mr. Chairman?
Senator Graham.
Yeah, I will join my colleague, Senator Cotton, in opposing. If you're a foreign country, an ally of the United States, and you use Huawei technology, we tell you we're not going to share information with you because we believe that Huawei is an extension of the Communist Party, and that if our systems get hooked up to the Huawei system, for lack of a better way of explaining it, you could compromise our security. So we remember calling the Prime Minister of Great Britain at the time when they were discussing this, talking about our policy on Huawei. An ally, no better ally than Great Britain. At the time, a real friend. But I said, we just believe it's not in our national security interest for our allies to sign up with Huawei technology. The gentleman in question, after having been in the Department of Defense and working for the National Security Council, took on work in a firm, part of a firm, that represented Huawei Technologies. I find it hard to believe that we're going to make somebody an OLC lawyer for our government who decided it was okay to work with Huawei Technologies after having been in our government. That's just like bad judgment. So if we're telling our British allies and others, we can't do business with you if you sign up for Huawei, why in the world would we promote somebody who, after having been in the government, decided to represent these entities? I think that's just bad choice, really bad choice.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, I think Mr. Fonzone's nomination and the points made by Senator Cotton and Senator Graham raise larger questions. I'm thinking, as I heard the comments about the attempts that Senator Grassley, Senator Feinstein, and those others of us on this committee have tried to implement reforms to the Foreign Agent Registration Act. It's a fact that foreign governments, not just friends, but adversaries, hire lobbyists, law firms, accountants, other people here in Washington, D.C. who, unbeknownst to us, are working on behalf of our nation's adversaries. And the reason why is because the Foreign Agent Registration Act is full of loopholes. And it needs to be fixed. We take an oath of office to uphold the Constitution and laws of the United States, not to do the bidding inadvertently, maybe unwittingly, of our nation's adversaries. This is serious stuff because our nation's adversaries exploit this loophole in the registration of foreign agents. I'll just give you a quick anecdote. Back 2016, I was one of the chief sponsors of the law that they called JASTA, which created a waiver for sovereign immunity for countries that finance terrorist attacks on American soil. This is focused like a laser on 9/11. And the 9/11 families who lost loved ones on that terrible day came to us and they said, we think there were foreign nations who financed a terrorist attack on American soil, which resulted in the death of our loved one. And we'd like to be able to go to court to prove it if we can. And so 2 times, this very narrow waiver of sovereign immunity, foreign sovereign immunity in the JASTA bill, passed the Senate 100-0 both times. We actually overrode a veto by President Obama because I think we all felt like this was a compelling case and that these American citizens who, through no fault of their own, found themselves a victim of a terrorist attack on 9/11 should be able to go to court and seek recourse. I actually had a number of lobbyists on K Street call me and urge me to drop this legislation. They were working for the Kingdom of Saudi Arabia. Now, I'm not passing judgment on the facts, but I do believe the 9/11 families should be able to go to court and prove what facts that do exist if, in fact, there was a foreign nation that financed terrorist attacks on American soil. The next thing I knew, I had a group of American GIs, veterans, show up in my office and say, we're here because we think you shouldn't pass this law which would give recourse to the 9/11 families. And we inquired as to, what possible interest could you have in this topic? And they'd been sold a bill of goods. But they knew, and the people who paid their travel and their hotel bills to come to Washington to lobby against this JASTA bill, that if, in fact, members of Congress believe that, hey, this is something that our veterans care about, and they don't want us to do this, that maybe, just maybe, they'd be able to get some traction. Now, they weren't required to register or to let me or anybody else know that they were unwittingly representing the interests potentially of a country that financed a terrorist attack on American soil on 9/11. I found that outrageous. I found it downright frightening. So when Mr. Fonzone represents a company, Huawei, which is affiliated with the Chinese Communist Party, and which we have urged our allies around the world not to buy that telecommunications material because it's a backdoor into spying on their communications by the Chinese Communist Party. It does trouble me, as Senator Cotton pointed out, when someone who wants to serve in such sensitive positions has represented them. Again, this isn't so much addressed at Mr. Fonzone specifically, but I wanted to take the opportunity to talk about why this is not a trivial matter. This is a highly significant matter, but it's even bigger than this nomination to this important position. Thank you.
Clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Rono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch. Ms. Butler. Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Senator Coons?
Mr. Chairman, I did not vote on the second nominee this morning. There was a period where it was unclear whether members were to be allowed to speak to the nominees, and I requested clarification. You subsequently made clarification that members were going to be allowed to speak to nominees, and you went through the relevant precedent. So I'm prepared to vote for the nominee if you would call the roll again and permit members to speak who did not previously have the opportunity to speak.
Chair entertains that suggestion, and any member who wishes to speak
Mr.
to
Chairman, can we clarify which nominee we're talking about?
Yomi Lee.
Yumi Lee.
So if there are any senators asking for recognition to speak to the nomination of Yomi Lee before the roll call is called? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Mr. Rono. Mr. Booker. Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch. Ms. Butler.
Aye.
Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
To the authorization for subpoenas relating to the Committee's Supreme Court Ethics Investigation. I'd like to offer a manager's amendment HEN 23B86 and move for its adoption. Now that Robin Arkley has provided a substantive response to our inquiry, I am no longer seeking compulsory process against him. As his counsel told the Washington Post, quote, "We were treated fairly by the committee." In contrast, Leonard Leo continues to ignore our efforts, and Harlan Crow has refused to provide a sufficient response. All those in favor of the manager's amendment say aye.
Aye.
Opposed, no.
No.
Manager's amendment is adopted. Roll call on the manager's amendment. Secretary, call the roll. Clerk, call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons.
Aye.
Mr. Blumenthal. Mr. Rono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley. Mr. Cotton. Mr. Kennedy.
No.
Mr. Tillis.
No.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
Manager's amendment's adopted. We now turn to...
Mr. Chairman, I have two amendments at the desk.
Well, please let me
Okay.
make a statement. I'm going to recognize Senator Graham on the Republican side for the order that the members on your side will offer the amendments. He has already given me your name earlier, but I want to let you proceed.
Thank you, Mr. Chairman. If it's okay, Senator Blackburn, I think you have a couple of amendments. And as we get involved in this process, I just want to, when we did subpoenas of Crossfire Hurricane, one of the most corrupt investigations in the history of the country, can't remember, 16, 20 votes, can't remember what it was. So I'm glad we're having votes. I just want to remind the public who may still be watching this for some odd reason, this is going nowhere. This is a political exercise. And Mr. Chairman, I'm still dumbfounded that after voting a bill out of the committee that supposedly fixes this problem from your point of view, why we haven't brought it up to the floor. I mean, you have a solution, you say it was voted out of the committee and it's never been brought to the floor. You're doing an investigation to fix a problem that you've already had a legislative solution for? If you want to fix the problem, try to pass the bill that you claim fixes the problem. The reason we haven't voted on that bill, Mr. Chairman, and never will, is because there's just not the votes. This is incredibly, in my view, unconstitutional. So we'll play this game for a while. Nothing will happen. The subpoenas never get issued. The bill never gets voted on. But it's important enough to destroy the committee.